And with us now on the show is former Supreme Court Associate Justice Antonio Carpio himself. Justice, good morning and thank you for being here. Justice, I think you're on mute, so if we can just unmute ourselves.
Sorry.
There you go. Good morning,
yes.
Justice.
Good morning and good morning to our viewers.
All right. Well, that was a very, very interesting discussion during your forum yesterday at the University of the Philippines. You were one of the panelists, Justice, and you did point out the glaring inconsistencies in the Supreme Court's ruling in both their resolutions, from the definition of session days to that requirement of an administrative hearing for the second mode of impeachment. I wanted to ask you, Justice, how serious and problematic are inconsistencies like these in the rulings of the Supreme Court?
Well, first of all, in the original decision of the court of July 25, 2025, the court added several requirements on the second mode of impeachment, including the holding of an administrative hearing by the plenary. And the Supreme Court in this new resolution walked back all of that. In this new resolution, the Supreme Court restored the practice procedure before the July 25, 2025 ruling with respect to the second mode, the direct filing, the express lane. So we're back to the original position before the July 25, 2025 ruling. So that's safe already. The second mode, the direct filing, where 1/3 of the members of the House or more can sign and under oath the articles of impeachment, and the articles of impeachment will immediately be transmitted to the Senate. And this new resolution says that. Nevertheless, whatever it may be, once there are at least 1/3 of the members of the House signing the articles of impeachment, the same shall be transmitted immediately to the Senate. So we're back to the original, and I'm happy that the Supreme Court has adopted that. Our problem is on the first mode, on the session days, because in the first mode, you have a requirement that the impeachment complaint should be included in the order of business within 10 session days, and then referred to the Committee on Justice within 3 session days after it's included in the order of business. So in the original decision, the court said the House applied correctly. There was no breach of the 10 session day rule under the Constitution, but they were unanimous on that. But in this new ruling, they completely turned around and said there was a breach. And they said that session day should not be interpreted in the way that it has always been interpreted before in the U.S. Congress, in the U.S. states, and even in all our Congresses since the 1935 Constitution. It should be interpreted differently now. That session day means calendar day where there are plenary sessions of the House. There is no such rule wherever in the world that session days are calendar days where there are sessions, because the purpose of a session day is to stop the clock. Because if the deadline is today to pass the annual budget and it's the last session day, what the House will do, or Congress will do, is to stop the clock by saying we go on recess or we suspend the proceedings and meet tomorrow to resume. So that is considered one session day instead of 2 calendar days. So, but the court said that is not the interpretation that should be applied to the Constitution. They invented a new definition, and we're stuck with that now because the ruling of the Supreme Court is final and binding on all of us, and we have to live with it. So now, as of today, what will govern the pending impeachment complaints in the House will be the new definition of session day as calendar days where there are sessions. And the first impeachment complaint filed against VP Sara will reach that point this coming Monday. It will be, I am told, that it will, by Monday of next week, the 10 calendar days where there are sessions will have been reached. So the impeachment complaint against Sara will be deemed initiated under the new ruling. It's deemed initiated if the House does not act on it by Monday. So then that means the Committee on Justice will determine the sufficiency of form and substance of the first impeachment complaint. That is the status now. Thank you.
Well, Justice Carpio, as you mentioned and pointed out, the Supreme Court seemingly walked back on its own original ruling, and they didn't state any explanations for it. They simply left it at that. But Justice, does the court have an obligation to explicitly acknowledge any factual reversal, or can they simply leave it at that?
Well, they restated the facts in the new resolution. They restated the facts. They said in the old resolution they said there was no plenary vote to transmit it to the Senate. In their statement of facts, now in their statement of facts, they said there was a plenary vote, and they were unanimous in both instances. But we cannot demand the court to explain why it reversed, because it's factual. There was really a vote. That's caught on camera. There was a video, and that's in the House Journal. So that's established. You cannot question it. What you can question is the original decision when they said that there was no plenary vote, when in fact there was a plenary vote as documented in the House Journal and by video.
And I remember yesterday, Justice, you did mention the ruling has become quite chop suey, no, and mismatch. And you also argue that there can be no bad faith if lawmakers simply follow the prevailing interpretation of the rules at that time. So with that said, Justice, can the Supreme Court still argue that there was grave abuse of discretion? I mean, is that constitutionally defensible?
Well, whatever the reality is, the Supreme Court has ruled. And they are supreme even when they are in error. We just have to abide with that and hope that in the next case they will revisit the ruling and reverse themselves. But as now we're bound by that, Congress will have to follow that.
But normally, Justice, when a court creates a new rule, it should apply prospectively, right? But here
That's
the court
correct.
is applying it retroactively. Is that constitutional in itself? Can you walk us, Justice, through the process on when
Yes.
a rule can be applied retroactively?
Well, the general rule is a new ruling should be applied prospectively, especially if it will undo something that's already been done. In other words, if you committed an act on a certain day and that under existing law and jurisprudence, that was a lawful act, and a new law is passed or a new ruling by the Supreme Court is adopted saying that that act is actually illegal, it cannot be made retroactive because you never knew that it was illegal at the time you committed that act. Everybody thought it was legal. So you cannot, the due process says you cannot be penalized for an act that everybody knew was legal. Even the Supreme Court said it was legal. But later on, the Supreme Court reversed itself and said that act was actually illegal. It cannot be made retroactive because that will violate due process. So that is the doctrine of operative fact. A new ruling that reverses an old must be applied prospectively. Because it will violate due process. But in this case, the Supreme Court said we are retroacting it to February 5 when the impeachment complaint was sent to the Senate. Why? Because when it was sent to the Senate, it was illegal because there was no plenary vote. Because the rule is you can invoke the doctrine of operative fact if you did not commit an illegal or unlawful act. You are not in bad faith. So the Supreme Court, in its original decision, said the Supreme Court said the House, when it transmitted the fourth complaint, committed an illegal act, an unlawful act. They were in bad faith. So, but in this new ruling, the Supreme Court said they were the they were not in. It was not an illegal act. It was not unlawful because there was actual plenary vote. The basis of illegality was the lack of plenary vote, but it turns out there was a plenary vote. So that was erased under this new ruling. But even as it erased it, the Supreme Court still used it to retroact the present ruling that the new definition of 10 calendar days shall be retroacted to February 5 because the House committed that illegality of transmitting it without a plenary vote. But they already said there was a plenary vote.
Right.
They forgot in their own rulings that there was already they already said there was a plenary vote. So whatever it is, we're bound. The Supreme Court, no further pleadings. You cannot discuss this with us anymore. You have to follow it. The Supreme Court is supreme, even if it is wrong. So we have to follow it now.
But Justice Carpio, is there any legal recourse left, or is that it? As you mentioned, the Supreme Court already did say they have denied this motion with finality. But what does that also imply and mean now for the balance of power between legislative and judiciary? And do you think this will set a precedent where the court can now redefine legislative procedures?
Well, that's why in the next case, we have to bring it up again. Because this is a peculiar circumstance because of the situation of Sara Duterte. But let us assume now there is a new impeachment complaint against VP Sara. They will apply the 10 session days as newly defined by the court. And that will expire on Monday. So if the House does not do anything, it automatically goes to the Committee on Justice. And Sara Duterte cannot raise any issue against that because it's in the new ruling. So that will be the new normal now. She has to face this new impeachment because this is pursuant to this new ruling.
Okay.
And I don't think anyone would stop that because we want the process to continue. And we cannot change that anymore because the ruling of the Supreme Court is final. So that will be the procedure, the practice that will be followed from now on until otherwise reversed by the Supreme Court.
But also at the end of the day, Justice, an impeachment process is a political game. It's a numbers game, as they say. How do you think the recent announcement of Vice President Sara Duterte that she will run for presidency in 2028 will affect the impeachment proceedings at the House?
Well, actually, the message she's sending is, I am leading the polls. I have, depending on whom you talk to, 30 to 40% of the people will vote for me. So if you impeach me and there is no, the numbers, they don't have the numbers in the Senate, so I will be acquitted and I will become president, and you watch out because I will remember who voted against me in this impeachment. That is the message. That's why she declared her candidacy.
But how precarious is this moment for the lawmakers themselves?
Well, everything is now clarified because of this ruling. Whether we agree with that or not, we have to follow that. So by Monday, whether you like it or not, because the Supreme Court in this ruling said it is mandatory for the House plenary to refer the impeachment complaint to the Committee on Justice. So it's really mandatory. They don't have a choice. By Monday, it has to be referred. Whether they do not act on it or not, it is considered initiated already by Monday. So it's there now in the House Committee by Monday, Committee on Justice. And the first thing that the committee will do is to determine whether it's sufficient in form. And if it's sufficient in form, they will determine whether it's sufficient in substance and then call a hearing. VP Sara will have to file a comment and there will be a hearing. She will have to present her evidence and the complainant will present his or their evidence. And there will be a ruling within 6 session days, which is now newly defined. Within 60 session days, which is now newly defined. And there will be a vote in the House. And if there's still 1/3 voting, then the articles of impeachment will be transmitted to the Senate. The problem will be in the Senate.
All right, well, we're going to leave that there. Thank you very much, as always, Justice Carpio, for helping us understand all the legal intricacies when it comes to our justice system. Thank you very much for your insight. That was former Supreme Court Associate Justice Antonio Carpio.
Thank you also. Thank you to our viewers.